Right, Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera. So today I'm going to share with you and discuss on the law of contract. So this is a part 1, right? So we just begins our crux of the topic. So as you notice that the previous lessons are more on the fundamental basic of law, right? Introduction of the law. So today we're gonna touch on the one of the subject matter under the law, which is very important, which is the law of contract. Okay. So this is a part 1. There is will be another parts 2 or 3. Right. So what you will get in this lesson is one, you can explain the definition of contract, right? Understand the essential elements of contract, analyze types of contract, and also describe several principles and doctrine of law of contract. So these are 4 learning outcomes of this under the subject of the law of contract. Okay, definition of a contract, the essential elements of contract, types of contract. Okay, and the last is other several principles and doctrine of law of contract. Right. Okay, these are the contents of the learnings. Okay, we're gonna little bit touch on the introduction of the law of contract, definition of contract, essential element, type of contract, privity of contract, doctrine of promissory estoppel, remedies for breach of contract, discharge of contract, and then lastly is conclusions. So basically what we gonna learn is just actually on surface under law of contract. We don't actually learn the in depth as compared to the law students. They study a law of contract for 2 semesters. So they are focusing they are actually learn much on law of contract, but for non-law students normally we just touch on the on surface of law of contract, which is 2 or 3 meetings only. Okay, so okay, right. For a start, what is actually agreements or contract? Okay, right. So you may come across several definitions. You can Google, right? There are some definition given by the scholars, right? Okay, there are sometimes scholars may give their own opinions about the contract, right? Okay, but the layman might see the contract as just an agreement, agreement between 2 or more persons, and this agreement they want to bind to each other, especially on the terms agreed upon. Of course, in the contract, especially when it comes to the written contract. Written contract normally they have we call as clear terms, written terms of clear terms stated in the black and white. But bear in mind that some contract are not necessarily in black and white. They might be in the form of we call as by form of conduct or by we call as in verbal contract. Okay, verbal contract means it's not necessarily written in the black and white. Okay, for instance, normal verbal contract is when you enter into supermarket to buy some groceries, something like that. Actually, we don't need some kind of formal or black and white contract. We just put the items in the cashier, right, and then pay the price of the item, right, without giving any, we don't need actually to sign and in the give witness. We need some witnesses, right, to bring some witnesses or something like that. We just actually put the items and pay for the price of the goods. That's all. So that is a kind of contract as well, but it is not a written contract. Is a verbal contract. It might be verbal. Let's say I want to buy this, and okay, I agree, something like that. So even without saying I want to buy the goods, and that it is still a binding contract, right, and it's valid. So it's not true if somebody say that the contract must be in writing. Some contract, of course, without doubt, it needs it needs to be put in writing. For example, sale and purchase agreements, right? If you want to buy some real property, of course you need to be put in the writing, because the government the government has laid down several rules. When you buy real property, you need some, of course, you have a proper documents, right? You have to have a stamp for that. You have to pay for duty stamp. That's why they need to be put in writing, right? But for simple contract, like buying sweets, buying ice cream, right? Cendol, right? Ice kacang, something like that. We don't need actually a proper or formal contract. So that kind of we call as a verbal contract, or a conduct contract. We don't need say anything. All right, it just what matters more is just you have the money, and then you pay the price, and then the contract valid already, complete. All right. Okay, so talking about the law, of course, we have a specific act or statute that regulate the contract under the Contract Act 1950. So historically, this our Contract Act actually was originated from the Indian Contract Act 1872. So our the British at the time just imported, copied and paste the Indian Contract Act into the Malaysian Contract Act. They just substitute the name of the India and Malaysia only, right? Sorry. Because why? Because India is one of the once colonized by the English. So that's why the legal system is much identical in terms of legal system. The contents might be different, but the legal system much identical with Malaysia, right? Okay, so in Sabah and Sarawak, it was accepted later in 1928 and 1938 respectively, right? Alright, this is the reception of the law of contract in Malaysia. Alright, so come to the definition of contract. Okay, this is a legal definitions. So previously we were talking about layman definition. So this is legal definitions. So legal definition of contract, it is stated under section 2 subsection H, Contract Act 1950. It says that an agreement enforceable by law is a contract, right? An agreement enforceable by law, which means that contract is an agreement between two or more parties that are enforceable by law and legally binding, right? So we need to say only the law only recognize only recognizes those contract which is enforceable by law, because some contract are not enforceable by law. Some agreements, they are not recognized, thereby is not enforceable by law. For example, like a contract which is not enforceable is a contract of let's say we call it as void contract, whereby the considerations void. Right. Okay, guys. These are the essential elements of contract. There are, all in all, there are 6 elements, essential elements, by hook, by crook, that all these elements have to be fulfilled before we can say that a contract is enforceable by law. Okay. So if one of these element is omits, if one of the elements omits, so the contract, most probably the contract will not be recognized by the law, right? So one is proposal, okay. Number two, the acceptance, and there must be an acceptance. Number three, there must be intention to create legal relations. Number four, there must be a consideration in the contract. Number five, there must be a certainty, and also the last one is capacity. So these are the 6 essential elements of the contract. So we will go one by one after this. Okay, first essential element is proposal. Okay, right. So what is meant by proposal? So the legal definition of proposal is stated under section 2A, contract act. So CA, so after this I will just say CA, so it stand for contract act, right? So what this provision says is that a proposal is when one person signifies, so the word here, the keyword, so I will underscore this, signifies, right? So when one person signifies to another his willingness, right? His willingness to do or to abstain. Do or abstain from doing anything, right? With a view to obtaining the essence of that other, right? To the act or abstinent, he said to make a proposal, right? So if you can see that there are some keywords here, right? So the proposal is made when one person signifies to another. Signifies means something like give, what you call that, when somebody we call communicates, something like that, communicates to another. Signify mean maybe some kind of they need the communications. To another his willingness, meaning to say what he wants, what he wants, willingness, right? To do something or to abstain. You know the word to do, I mean, is very common. To abstain is something means not to do. Meaning to say a proposal might be not only to do something, to ask to another person to do something, but also not to do. So for example, like if the lecturer, if a lecturer says that if you go to the class, I will reward you 10,000 ringgit. So this is something to do, asking for doing something. But to abstain is something like if you don't go to the class, I will give you 10,000. So that is also a kind of we call it offer for not to do, right? Okay, but of course most of times that contract is something that needs other person to act something, to do something. Okay, all right. With a view to obtaining the essence, so the other part of party must in a way that there is a probability that the other party must consent about it, assent or give some note, okay, give an agreement, give to agree with that kind of offer, right? Okay, and he is said to make a proposal, right? So that is the we call as the keywords of the proposal, okay. Signifies there must be communications, communicate with the other what he want to do or not to do, not to do, right? Okay, I give you example here. If a person advertise in the Star that he will reward 1,000 to anybody who find his cat. So this we consider proposal. So this kind of there is a communication here, in the newspaper, right? And also there is a reward here. What the proposal is about is 1,000 to who find his cat. This is something to do, right? So this is considered a proposal. So further under section 2C, define promisor, is the person who make a proposal, and promisee is the person accepting the proposal. So there must be at least two parties, in the contract. There must be at least two parties. One we call as the person who make a proposal, which is a promisor, and the other party who accept that proposal, called as a promisee. Okay, there cannot be a unilateral contract. Meaning to say there cannot be only one. There must be somebody else who accept the proposal. Okay. Okay, for instance, like this, in the football league, for example, right? When this person, let's say this Liverpool, right? The coach, let's say offer this player, to play with Liverpool, for example, right? So he is asking this player, to be part of the team, then with the some salaries, right? So that is kind of a proposal. So the proposal, person who make proposal, again it's called promisor or offerer, right? Okay, sometimes you come across this word, and also sometimes we come across the word offerer, but they are same thing, and then the promisee, the other party, and also we call as a offeree. So they are synonymous, so don't get confused lah if you come across the word, especially the offerer and offeree, right? So what kind of form of proposal, so the proposal can be express proposal, which is express means clear, direct, direct, express or direct proposal, for example writing or verbal. So it's very clear and direct, to be more clear is a kind of writing lah, so verbal might be is also direct, but it will actually give, maybe will raise a issue, later on in the evidence, but writing is very express, direct, and it is very clear evidence, so the second one we call as indirect proposal. Okay, it is made by the conduct of the parties. So this kind of proposal is little bit complicated, So sometimes it will raise some issues later on, because there is no such we call as a clear a kind of proposal, so it is made by only, for example, like by conduct of the parties, or sometimes it can be the combination of the above methods. It can be writing, and conduct, so it can be verbal and conduct, so that's why sometimes the court will look to the will examine the fact of the case, to analyze or to determine whether there is a contract or not. Sometimes the court take into consideration the conduct of the parties. The conduct of the parties, for example, the conduct means, for example, let's say if I offer you, for example, to sell, I want to sell my car to you, right? I want to sell my car to you, and for some price, right? And then you agree. You don't give an agreement, but you drive my car, you drive my car for example, like 1 month or 2 months or a year. So the fact that you use my car, for a period of, we call it unreasonable lah, for a test drive, it might give some clue, right, whereby the court will determine that the conduct, the fact that you use the car for a long time, maybe there is a conduct, we call it as that you agree to buy, so it means that it indirectly, even though you don't give a signal, direct signal that you say you agree, but the fact that you use or you drive the car as it is yours, then it might give some indirect evidence lah, for the court to determine that there is a contract, right? So this is what we call as a conduct, conduct of the party. Okay. Okay, another question or another issue is to whom a proposal can be made, right? So the proposal can be made either to a particular person, right, or to the public at large. Okay, to a particular person is very common, whereby you directly offer, when a promisor directly offer something to the promisee. So the promisee, there is an identified promisee lah. So example like an agreement is made by Ali and Achong in relation to buy sell house. So this is very particular, very specific parties. Okay, there is also another scenario whereby the proposal is made to the public. It's not meaning to say it is made without any specific names, specific names for the other party. So example like when a person who loses his cat and made an offer in the newspaper, promising to anybody to reward a certain amount of money to those who find his cat, and return it back. So this kind of proposal is made to the public. So we need to say anybody who finds the cat and return it back, so he will give to reward to him, right? So this is another kind of proposal lah, right? So we have a landmark case here, the case of carbolic smoke ball. So this is very old case, right? The very but it's very popular, very popular case, Khalil and Carbolic. So the brief fact of the case is that the company, Carbolic Smoke Ball, advertised in the newspaper, right? At the time is, I think it's 1980 something. 80 something is very almost 100, more than 100 years ago. So the company actually manufacturer of a product. So the company advertise and offer £100, right? Pound sterling, to anybody who suffered or succumbed to influenza after using certain remedy for fixed periods. So this manufacturer of remedy lah. So the plaintiff used it, but nevertheless contracted influenza. So the plaintiff in this case sued the defendant, the company, for the money promised lah. So the court held that the plaintiff was entitled to the reward as he had accepted the offer made to the world at large. So the term is that the company offer 100 pounds sterling. So and it is actually fulfilled by the plaintiff. So the fact that the plaintiff has suffered influenza after using the product, that is actually has fulfilled the terms of the contract. So that also considers as a contract. But this is an example of a contract when the proposal is made to the public at large. Right. Okay, another issue or another question is that when is the communication complete? So as you noticed just now, I have explained that the proposal must be communicated. The proposal must be communicated to the promisee by the promiser. Okay, so the issue is that when the communication or proposal is complete. Okay, so under section 4, it says that the communication or proposal is complete when it comes to the knowledge of the person to whom it is made. Meaning to say, example like in the case of Kabalik Smoke Ball, right? When the plaintiff actually read the newspaper, right? So it means that the communication has completed already. The communication or proposal, not certain. The communication or proposal is complete already when the plaintiff read the offer in the newspaper. Okay, so mean to say it has come to her knowledge. Okay, but for a contract to be, bear in mind, for a contract to be complete, so both communication must be complete. Mean to say a proposal and the acceptance, the communication of proposal and acceptance must be complete. Okay, so on the part of the promiser, right, the proposal is complete when the promisee, against the promiser lah, the proposal is complete when the promisee knows about the promise. Okay. So another question is that whether a proposal can be revoked or not. Right. So this is another issue because sometimes the promiser made a promise, proposal, but he or she actually he want to make up his mind by revoking the proposal. So in that kind of situations, right, the law under section 6 has laid down circumstances whereby a proposal can be revoked. One is when the communication or notice of revocation, need to say the proposer or promiser communicate to the promisee or either to the public to revoke the offer. Number 2, lapse of time, means there is a expiry of time, especially when the offer has some terms of the period of time. Let's say 1 year, 1 month, okay, 1 day or 1 hour, something like that. Okay, so after the expiry of that particular time, then uh, the proposal is expired lah. So that's what it means as a lapse of time. Number 3, failure to fulfill a condition, precedence to proposal. Okay, so this needs actually when the promisee has tried to fulfill the conditions, but somehow he failed to fulfill what is required under the promise, under the agreement, the proposal, then it is also considered as a revoke. The last is death or mental disorder of proposer or promiser. Okay, so when the promiser is dead, or has a kind of mental disorder, so these two kinds things that can make the proposal is automatically revoked. Automatically revoked. So it is 4 types of situations lah. Okay. So in terms of number 1, communication of notice. Okay. So in terms of notice, sometimes the promiser, when he or she want to revoke the proposal, he might give some notice. So notice, it might be in the form of, we call it as instantaneous, swift notice or quick notice, let's say by call or something like that, or through we call it non-instantaneous, like a notice through via, we call it letter. So that is sometimes needs needs time to be complete. But there are some rules. Later on we will discuss this. Okay, the second what we call the elements, elements or essential element of the contract, we call it acceptance. So when there is a promise, there must be also acceptance. So what is meant by acceptance is when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So once the proposal being made by the promiser is accepted by the promisee, so this is considered as a acceptance. So we need to say there is also communication whereby the promisee signifies that to the promiser that he or she agrees to the proposal made. Okay. And one more thing that which is also more important is that the acceptance must exactly fit the proposal. Okay. So what is meant by fit? Maybe it must actually what is we call that needed in the proposal must be fulfilled by the promisee. If, for example, the promiser wants A, so the promisee the must accept is A as well. It cannot be B or C, right? Okay, and also the acceptance must be absolute and unqualified for it to be effective. So there is no such other conditions attached. No string attached, we call it as a language form. No string attached. Okay. So any modification will constitute we call it as a counter proposal or counter offer. Okay, this term is a legal term, counter offer, because sometimes the when the promisor made the proposal, let's say A, the promisee made another proposal, which is B example. So that is we call as a counter offer. So when the counter offer is be made, so it's not considered as acceptance. It's not considered as acceptance unless both party agree. Unless both party agree to that counter offer. Okay. Okay. If the other party or promiser just keep silent about it, though, so it's not considered as a acceptance. Right. Okay, again, communication of acceptance. Acceptance is effective when it has been communicated. Okay. Further, it must be made with a reasonable time. Of course, especially when the contract has certain terms of a period of time, for example. So the acceptance must be made within a reasonable time. Okay. Okay, again, likewise, the acceptance can be revoked as well. As what in the offer, okay, the acceptance can be revoked. So the situation are the same like offer. Right. As for poster rule, actually I have made a special video. So we jump this poster rule. But what I want you to know that poster rule is one of the issues issues in the communications of proposal and acceptance. Because as I mentioned in the earlier lecture that uh, there are two kind of communications in proposal or acceptance. One is instantaneous, and another one is non-instantaneous. Okay. For instantaneous communications, there will no so much problem because the way that the communication of proposal and acceptance made at in a impromptu or something like which very in a quick way, right? So there is no such problem in that. The problem is that when the proposal or the acceptance is made in by means of non-instantaneous, which is very very slow in communications. For example, by through the post, right? To the by letter or by the fax, right? Even by email, even email, there's also a problem because even though the email, once you submit or send the message through email, sometimes is not actually being known by the other party at once. So that is a problem. So for poster rule or other rules which is by what you call that in such way the means of the communication is slow, so we have actually special video for this. So we jump the poster rule afterwards. So we go straight to the other topic, subtopic. Okay. Invitation to treat. Invitation to treat. Right. So invitation to treat versus proposal. Right. Invitation to treat is a kind of negotiation. It is a preliminary communication between parties at the stage of negotiation. So in legal perspective, invitation to treat is not considered as a proposal. Therefore, it's not enforceable by law, right? Because the law considers this type of communications is actually the parties are not actually ready to bind to each other. It is a stage of preliminary communications. It's a stage of negotiations between parties involved. So how to distinguish or differentiate between a proposal and invitation to treat. The word invitation, the invitation to treat is by looking at the fact of the case. So the court will determine whether the parties tend to be bound to each other or not, by looking at the fact of the case. But there are certain, of course, common principle that have been established in the court, that certain transactions are not considered as a proposal, right? So for example, like in the auction, in the advertisement of auction, so you correct this, so you add some more the word advertisement of auction. So I think you have come across this in the newspaper. There are some companies or some even the government bodies, they make an auctions and advertise in the newspaper. So that kind of advertisement of auctions is not considered as a proposal. Therefore, if somebody accept that the what you call the auctions in the advertisement, the auctions, they are not cannot be enforceable by law, right? Same goes to display of goods. This display of goods, example in the supermarket, or in the pharmacy, for example. Uh, when the owner of when the shop owner, they display some goods in their shops, it doesn't mean that they are actually offering, we call it, make a contract, so meaning to say, what the law says is that, right, if we consider that display of goods as a proposal, right, meaning to say, whoever sees any goods in the display racks, or any goods in the showcase, for example, any clothes worn by the what you call it, the doll, right, in the showcase, it means that shop owner have to sell that particular kind of goods, okay. But instead of that, the law actually, through the case, right, considers that display of goods are not considered a proposal. Meaning to say, you cannot force the shop owner to sell whatever goods, whatever items in the rack, right? So that is the rule. Okay, number 3, job advertisement. As job advertisement of auctions are concerned, so job advertisement also are not considered as proposal. If we consider the job advertisement is a proposal, meaning to say, whoever sees the advertisement in the newspaper, the employer has to accept that reader, right? So that's why job advertisement, auction is not considered as a proposal. Same goes also to quotation, when the company forward the quotations, also not considered as a proposal. Same goes to automatic vending machine, right? Okay, for automatic ticket machine, also tenders lah. So quotation and tenders, they are more or less same, okay. So let's say in display of goods, so when actually this kind of, for example, like auction is considered as a proposal, is when the auctioneer actually make that uh, auctions during the auction of the day of the auctions, and then when he says uh, once, twice, and third, and sold. So sold mean so nobody bids that particular item, so it's considered as a proposal and acceptance lah. Okay, same goes to display of goods. So when the display of goods is considered as proposal is when the the customer brings that item into the cashier, and then the cashier give the money, give the money for that price of the goods, then it's considered as a proposal and acceptance. Okay, same goes to job advertisement when the candidate of the employee, right, goes to the interview, right, and then the once the employer um, uh, issue a letter of what you call that, letter of employment, so that letter of considered as letter of offer, letter of offer of employment, so that is proposal. Okay, so to some extent, so the law, in other words, considers this kind of scenario, like this, are considered as still at the age of at the stage of negotiations. But of course, after a certain stage, they come to be as a proposal. Like automatic vending machine, display, just you want to buy a coffee, so we can see that automatic vending machine just displaying the particular coffee, right? So that is considered as a invitation to trade. But once you put the money, right, you put the money, but the, let's say, the item, the coffee is not it says that it's not sold out, but you have to put the money already, so that is considered as a proposal already, so you can claim for that. Okay, so the fact that automatic vending machines, the fact that, for example, like it's sold out already, but you still want to buy that one, it cannot be, it cannot be enforceable, right? Okay, same goes to quotation. If the question has been accepted, right, and the person who offer that particular you know quotations agreed for that quotation, then it's a proposal. So but early quotation, just submit the quotation, is not considered as proposal. Okay, right. So we have a case here, Harrison and Nicholson. So this case happened in 1873. A very old case, right? Still remember, right? The common law principle, right? So this is kind of common law principle where we import the law from England, right? So in this case, an auctioneer advertised an auction in the newspaper, right? So the keyword is advertisement, and auctions. So Harris saw the advertisement and traveled to the sale only to find that item, in which he was interested in, bidding had been withdrawn. And it's very unfortunate, that the item has been, the bidding had been withdrawn. Right. The issue is whether the advertisement on hold the auction was a declaration of intention to hold the sale or an offer that was accepted by intending. So the court held that the advertisement of the auction was not a guarantee that it will be held, but simply a declaration of an intention to trade. There was therefore no contract. Okay, so this also applies to advertisement of job. Okay, so only the fact that you read that particular advertisement of job doesn't mean that the employer has to accept you as an employee. Okay. Okay. The element number 3 for valid contract is intention to create legal relations. Okay, for this particular subtopic, intention to create legal relation, obviously there is no law in the Contract Act, right, that regulate this particular element of valid contract, but it actually was established it was established by the principle issued by the judges in the court. Okay, it's a unwritten law. Okay, it's unwritten law. So based on the precedent in the cases, right. Okay, for as far as the contract is concerned, is silent about the intention to create regulation. But for case law, they are required to have that kind of intention. Okay, so English law approach and cases. So based on the English law, so this is the principles, right? Based on the cases, there are two type of transactions under the contract. Normally, there are two types. One is social, family, or other domestic agreement. We call it as domestic agreements. And another one is a commercial agreement. Okay. So social, family, other domestic agreements. Example like agreement between husband and wife, parent and child, and also between siblings, among peers. So that is considered as domestic agreements. And another one is commercial agreement. For example, like always like you in agreement, like you want to go to buy something in the shop. So that is also is considered as commercial agreement. Okay, so the presumption under the law is that domestic agreements, the law assume that the parties actually there is no prima facie, we call it as prima facie, right? So that is presumption lah, prima facie. Okay. So it is a presumption under the law that in domestic agreements, the parties are not actually don't have actually intention to create legal relations. So when they don't have intention to create legal relation, meaning to say there is no contract at all, unless these parties, okay, or the parties concerned can rebut this presumption. With the word rebut, you have to look at your dictionary, what is meant by rebut. So if the parties aggrieved party can rebut these presumptions, so the court can actually declare such a domestic agreement as enforceable by law. But in other words, it's not actually conclusive lah. Meaning to say, we cannot say that since it's a domestic agreement, we just always assume that there is no contract. No, it is just a prima facie. It's just a prima facie, right? But for commercial agreements, okay, it is also prima facie that the parties have the intention to create legal relations. So it is the other way around. Okay, the other way around. But I think for commercial agreement, there is no such disputes whether it is the parties have intention or not, something like that. So it is assumed standard presumptions. Of course, when you go to 7-Eleven, don't tell me that you don't have a intention to to buy something which is, when you buy something in the 7-Eleven, for example, don't tell me that you don't have a so-called commercial agreement. Okay, so it is known as commercial. Right. So we have several cases here, right? In domestic agreement, example like Balfour and Balfour, and married and married. So for commercial agreement, we have a case of Loh Kayit versus Muhammad Isa, and Diamond Development Sambrahat versus Matthew Luchin Tag and another. This is stand for not Anno. Anno is not name person, but is another. Another lah. Okay. So guys, what I want you to do, please find this Balfour and Balfour, and Married. You can just Google, and for the next lecture we discuss the fact of the case and what the court says about the case lah. For Loh Kayit and Diamond, I will provide you this case, because these are Malaysian cases. You might probably you cannot actually find it in the through Google. But Balfour and Balfour, as for Balfour and Married, they are available in the internet. Okay. Okay, so I skip this for you, just for your homework, right? Okay. All right. So the fourth elements, the essential element of contract is considerations. So as far as the consideration is concerned, right? It is stated under section 2D, 2D of the Contract Act. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstain from doing, or promises to do or to abstain from doing something. Such act or abstinence or promise is called a consideration for the promise. So the term considerations, bear in mind that the term of consideration doesn't mean that we take into account something. It 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 doesn't mean it doesn't actually connotes the meaning of when you take into consideration something like that. It's simply that consideration in this respect means what the promisee has to do something to do or abstain something in return. In return, what the promiser has made. So, in other words, what is the something in return? For example, like example, if A promise to B that he will give 10 ringgit provided that B can hand over the book to him. So the handing over the book, right? The act of handing over the book, it is a kind of considerations. In return, what the promise made by the promiser. So the rule of consideration is that it must come from the promisee or any other person on behalf of the promisee. So the third party may also act on behalf of the promisee for the consideration to be made. Okay, that is number one. So for number two, okay, bear in mind that considerations is not something only to do, but also it can be something which abstain from doing something, not to do something, or abstain. So in this respect, if you can view or can see the definition of consideration under section 2D, it has three situations actually. It has three situations in which that we will discuss later on. Right. So let's say if I can say quote here, If I can quote here, has done or abstained from doing, number one. Okay, so I highlight this one. Okay, number one, let's say example, has done or abstained from doing, number one. That is number type of one. Does or abstain from doing, that is number two. Type number two consideration. Number three, promises to do or abstain from doing. Okay, so there are three situations in which that the consideration can be made. Okay, later on we will discuss this. So, but I just want you to understand, comprehend uh, the definitions, the definition of the term considerations. It's not something that you take into account or take into considerations. It is something that what you give in return, in return of the promise. Okay, something in return. So that something in return, so many lah. It depends on the what type of consideration that the offer requires to, right? It can be some rights, interest, profit, benefits, forbearance or detriment. Okay, forbearance or detriment is something which you have suffered something, because of the promise you have suffered something, so that is meant by forbearance or detriment. Loss of responsibility given, okay, suffered or undertaken by the other. Okay, right. So obviously we have several types of consideration. We have, legally speaking, there are three. There are three types of consideration. One we call as executory considerations. Number two, executed consideration, and number three is past consideration. So I just want you to remember, for executory consideration is a kind of consideration whereby is a future consideration. It's a future consideration. For example, if I give you 10 ringgit and I want your book, so you say that okay, I give you a book next week. So by giving the book next week, mean it's considered as a executory considerations. So it's considered as a value binding, right? So the consideration mean to say it is done, it will be done in the future, right? For executed consideration consists of doing an act right now, at once. Mean to say if I give you 10 ringgit, provided you give me the book, so you give at once your book. So that is considered as executed. For type number three is a little bit complicated, whereby the consideration is being had been made first, then the promise come later. Okay, so that's why it's very complicated. So for example, I give you example. If Ali asked Betty to look after his son, and later promise give Betty 300, so Betty acts in looking. Okay, so the act of actually the act of looking Ali's son, as Ali's son, is had been done first, had been made first. Okay, so I give you another example which is very simple. Let's say somebody is drowning, somebody is drowning, right? And you are witnessing that kind of drowned people, drowned persons. Then you save that person first. Okay, you save that person first, and then when that person had been saved, right, he promised you to give you some amount of money, right? So the act of saving that drowned persons is considered as a past considerations. okay, whereby the offer of giving the money as a promise is comes later. Meaning to say consideration came first, and then later the promise. So that is we call as past consideration. If you see this example a little bit, it's a bit quite confusing lah. But the simple things that I give an example just now is saving the drowned persons. So that is very simple lah, right? Okay, another issue in consideration is concerning the adequacy and insufficiency of considerations. So the rule under the law of contract, and as far as the consideration is concerned, the law only requires that consideration is not necessary must not necessarily be sufficient. You have to differentiate between the word adequacy and insufficiency. Okay. Example, I give you example like if Ali buys a house worth 1 million for 2 ringgit, the contract is valid and enforceable. Okay, so in this case, by giving 2 ringgit for 1 million house might be for some people think that it is insane, right? Because it is inadequate. It is inadequate. But for the law actually doesn't take into account or doesn't take into account the adequacy. It's just sufficient only. That's why if you buy a house for 2 ringgit, which is apparently that the house worth 1 million or more than 2 ringgit, the contract is still valid. So the fact that because if you see the explanation 2 of section 26, it just said an agreement to which the consent of promisor is freely given is not void merely because the consideration is inadequate. Okay. So 2 ringgit might be inadequate. Of course not adequate lah. If you ask me, of course it's not inadequate for 1 million house, right? But the law recognizes this particular transactions, considerations, provided that the promisor is freely given. The consent of the promisor is freely given. There is no such element of force, fraud, or something like that. Okay, or vice versa. Sometimes you in the auctions we can see that people bid for particular item, for example like 10 cents shilling, which is for for many people say that a lot of people say that this is insane, right? But it is sold for 1 million, so something which is ridiculous, right? So it can be way around lah. The house might be worth the worth of the house might be 1 ringgit, but people buy it for the 1 million, something like that. So it can be work vice versa, right? So there are certain promises that the law deemed to be of no value and insufficient considerations, right? Example like moral obligations. So moral obligation mean to say let's say morally obligation lah, like for example, what kind of moral, like for example, like uh, you help, for example, somebody lah, for old man, for example, senior citizen, helping back, for no reason, so that is kind of like a moral, or performance of the existing duty, like the duty of the police, for example, during their on duty, right? So that is actually considerations that, meaning to say, the police cannot claim for any particular, we call that, act of saving people when they are on duty, right? So it's we call as the law as insufficient considerations, right? So of course, in contractual duty is a duty of the parties involved lah. Okay, when the duty is laid down in the contract, so it cannot, you cannot actually claim for that, for the extra payment, for example, for considering that there is extra consideration, because it is obviously it's under the your duty, so you cannot claim for the extra claim for the that consideration, whatever things that you do within the contract, right? Within the terms under the contract, so it's considered as insufficient consideration. Thereby, you cannot claim for extra lah, for that particular act. So okay, guys, these are the checklists of our lessons, right? So I want you to make some kind of review, whether you understand or not the subject matter, by answering the checklist. For example, what is meant by a contract? You can, if you can explain the definition of contract, that means you understand this subject matter. And then okay, then the rest lah. So I hope that uh, you can test yourself, okay, check yourself whether you can answer or not this kind of questions. Thank you. So we will discuss our next subtopic in the part 2. Right, bye.